Welcome to the Capitol Forum Antitrust Interview Series, sponsored by Kroll on Track. I'm Nate Soderstrom. I'm here today with Melissa Maxman. Melissa is the managing partner at the Washington office of Cohen and Gresser, LLP. Melissa, thanks for being here today.
Thanks for having me again.
Wanted to talk a bit about the O'Bannon case, which, as we were discussing before we went on, has been going on for quite some time. I wonder if you could talk initially a bit about the theory of harm in that case, the antitrust theory of harm. What did the plaintiffs allege? What was the anti-competitive conduct what we're worried about?
Thanks, Nate, and I'm delighted to be here. Thank you for having me. Once again, I feel like this is deja vu all over again. We were discussing the fact that this is the third year I'm talking about Ed O'Bannon versus the NCAA, which I was fortunate enough to be on the trial team for the plaintiffs. In 2009, we filed on behalf of Ed O'Bannon, who was a fabulous basketball player, but he went to school on a scholarship, and his professional career was cut short because of injury. And he was watching video games at his nephew's house, and he saw himself on this video game in cartoon, and he said, "How come I didn't authorize them to use my name and likeness? I'm broke. I'm selling used cars in Las Vegas. Why shouldn't I get some of the millions of dollars that people are making on me in video games?" And the Hausfeld firm, which has been the lead firm on this case for some time, put together a complaint on behalf of O'Bannon as the class representative for a class of former Division I amateur football, excuse me, but Freud was a genius, of amateur football and amateur basketball players who are not being compensated for the ongoing use of their names and likenesses, and also many of whom are really struggling just to get through college because they will have their college paid for, but so the tuition is paid for, and they'll have room and board paid for. But sometimes these are big guys, and they're not allowed to take any outside jobs while they're in school, except football and basketball. Anybody who just lost money like I did on the NCAA March Madness knows that these are hugely profitable for the NCAA. There were some really strange restrictions put in by the NCAA, including how much, because they were trying to prevent students from being bribed or being treated better by certain schools, and so they're trying to level the playing field. I understand that, literally trying to level the playing field, but in order to do so, some of these men weren't getting enough to eat. There were rules that defined what was a snack and what was a sandwich, so they could be provided with a bagel, but if you had a bagel with cream cheese, it was a meal and it couldn't be provided to you gratis. So the theory of the case was that the NCAA is essentially a cartel of its member schools, which are restricting compensation to its athletes, to its Division I athletes, by not permitting them to accept employment outside of school, by not permitting them to recover very lucrative recover on the very lucrative contracts that the video game manufacturers are making, and for which they pay the NCAA millions of dollars in rights every year, but none of that was going to the athletes themselves. And also limiting the amount of scholarship money that athletes were allowed to take because it wasn't covering their needs. There are horror stories about athletes from very poor urban areas who go to school far away, didn't have the money to go home when his mother was sick, and nobody could pay for it. Or there are additional horror stories about they're hurt in school, they can't play anymore, and when they get out of school, they've had pins put in their leg or something, and they don't have the funds or the insurance to have the pins removed, which is what you're supposed to do. So that is the class, and that was the theory of the case. It was an emotional case in many ways.
Understandably, a lot going on there. In the district court, that was generally a win for the plaintiffs, not kind of.
Well, yeah,
certainly.
it was one for plaintiffs. You can just say it.
Right, it was a win for the plaintiffs. Going to the appellate level,
Yeah.
I know what the NCAA had argued in part was that, look, the district court should have been bound by the Supreme Court's decision in Board of Regents, 1984 case. That argument seemed like it was met with some skepticism at the appellate court level. But I'm wondering what your take was on the NCAA coming in and say, look, the Supreme Court has decided that student athletes can't be compensated, and your decision in O'Bannon went against that.
Well, I think that's an oversimplification of what Board of Regents says. What Board of Regents said was that the NCAA could lawfully manage restrictions, could compel member schools to schedule through the NCAA, for example, because you don't want Michigan scheduled to play both Ohio State and Notre Dame on the same day.
Oh, that'd be terrible.
Exactly, especially for Michigan fans. But when you are stepping into the area of compensation, the NCAA had less latitude about what it could and could not lawfully within the bounds of the antitrust laws order its member schools to do. And there are numerous other smaller cases, not Supreme Court cases, where the NCAA had restrictions on what assistant coaches could be paid. You can't do that because it crosses the line from how to keep the players playing and the games playing properly and into financial areas where you're restricting how much money the member schools can get, where you're restricting how many television shows or how many television broadcasts there can be of games. Board of Regents is 1984. That's when the floodgates opened, and all of a sudden, instead of seeing one game on TV a week, you could see as many as the TV stations wanted to broadcast.
Which I think we'd all agree was a positive development.
Well, I think so. I think a lot of people would agree. But what it did is the Board of Regents kind of opened the floodgates into, okay, this is big business. This is big money. I have heard athletic director after athletic director, because I've been speaking at a lot of these sports law seminars, say, the Division I sports are so important to our team. The athletic department is the front porch on the school, on the house of our school.
You see the applications go up every
Applications
time,
go up.
The national championship.
Exactly. I'm sure Villanova is going to do very well this year.
There's no question.
And so I disagree with that because, in fact, they were taking a very small slice, the NCAA, of what Board of Regents said, and they were trying to make it something else.
Right.
Judge Wilkin had written an extensive opinion. I mean, she had a 3-week bench trial. I think her opinion was very well reasoned, and she had actually already scaled back the scope of what the plaintiffs could seek, because the plaintiffs were seeking money damages retroactively, as well as affirmative injunctive relief going forward, so that the NCAA could no longer impose rules that would prohibit them from getting the money that they need just to get through school. And so money damages were out, and she said that was too complex it was unwieldy to manage something like that. That was in June of 2014. Shortly thereafter, the plaintiffs, believing that we had prevailed on the merits, or substantially prevailed on the merits, sought attorney's fees. And the NCAA promptly opposed our application for attorney's fees. Now, this case had been going on at that point for 5 years. It's now has been going on for 7 years.
So what attorney's fees?
Exactly. The attorney's fees, this is public. The application was over $50 million. And just in July of 2015, Magistrate Judge Cousins he went through extensive evidentiary hearings, literally went through $50 million worth of fee applications with a fine-tooth comb, and upheld most of them. And just on last week, March 31st, Right after Judge Cousin's opinion came down, NCAA moved for a de novo review, that is a complete review of everything from facts to law of his decision, which they're entitled to do, and also opposed his findings. And on March 31st, Judge Wilkin granted the motion for de novo review. She had obviously spent months going through these, and she went through 33 pages of, okay, I agree with Judge Cousins here because of this. I agree with Judge Cousins here because of this. She took, I think, $1 million off, but we're still well over $40 million in fees. In the meantime, not to be confused with anything substantive, the Ninth Circuit rather, came down in December of 2015, and basically upheld Judge Wilkin's opinion.
Right.
They did limit the remedies.
There was some pushback on the remedies.
Exactly. She had granted 2 remedies. One was an injunction prohibiting the NCAA from limiting the amount of expenses that could be reimbursed for students. She also prohibited the NCAA from preventing the students to have up to $5,000 a year put in an escrow account for them when they graduated for royalties for their names of uses and likenesses. The Ninth Circuit, in a 2-to-1 decision, said, we agree that this is cartel activity, so they upheld her substantive decision on the merits. And they also upheld one of her remedies, which was precluding the NCAA from limiting the amount that athletes were allowed to be reimbursed for their living expenses while in school. However, they did send back the $5,000 per year escrow account, saying that that went beyond what she should have done. And so she's reviewing that now.
Gotcha. So,
right.
And I should interject now. So the plaintiffs have decided that the Supreme Court should take a look at this.
Well, so what happened is the NCAA asked the Ninth Circuit for en banc review, as did the plaintiffs actually. The Ninth Circuit, at the end of December last year, denied en banc review. So then there was a period of time during which they could apply for cert. And February 13th, Justice Scalia died, unfortunately. And, I'm not sure, because there's so many other NCAA cases percolating up through the system, that this was the one they were going to take anyway.
Right.
Plus, some of the issues that the NCAA is appealing probably aren't necessarily cert issues. Whether or not a plaintiff has substantially prevailed on the merits, entitling it to attorney's fees, doesn't have the kind of ripple effect, doesn't have the precedential effect that the Supreme Court usually takes,
Right.
which is really their big issue. Their other big issue is obviously whether or not the NCAA is a cartel or acts as a cartel. And so on March 7th, the NCAA asked for and received from the Supreme Court an extension of time to decide whether or not to seek certiorari. Speculation is it has something to do with the fact that Justice Scalia died and that it appears that we're not going to have a new justice anytime soon.
Right.
Meanwhile, the plaintiffs thought, let's seek cert. And so on March 15th, we filed for cert. April 14th is now the deadline next week when the NCAA can either seek cert or not.
Right.
So we're once again in procedural purgatory.
As has been the case for a while.
That being said, if the Supreme Court denies cert, we get paid. I'd be very happy about that.
There you go. What is the path forward here, both for this litigation? You mentioned some, I wouldn't necessarily term it follow-on, but there's a bunch of litigation around the NCAA now. What do you see the path forward, both for your litigation, both for this other litigation? What should people look for?
You know, it's interesting. I think a lot of this has been incremental. I remember back in 2009, we were discussing, do we seek an injunction declaring that they're professional players in fact? Do we try to upturn this fiction of amateurism, or do we just take it a step at a time? And the decision was we were going to take it a step at a time. In many ways, this has cleared the path for athletes behind us or class actions behind us, current athletes, to say, well, if it's a cartel, then we can push the remedies even further. And that's what they're seeking. Or with the Northwestern students seeking to unionize. There are many, many different ways that athletes who have their college experiences largely revolve around, if you're Division I, playing football or basketball, your duty to the team. So they have a very different college experience from people like me who played lacrosse in college with wooden sticks with other women. Nobody wants to watch us on TV.
Oh, that's not true. It's interesting. It's been, as you pointed out, it's been incremental. It hasn't been kind of all at once, and certainly there seems to be a path forward for some of this. We could see more radical change when that happens. I think is anybody's guess.
A lot's going to depend on whether the Supreme Court grants cert. If they don't, I mean, I think the initial fee petition will be upheld. The NCAA does not have any additional place to go. I don't know, given the other cases that are working their way up through the legal system, that O'Bannon is going to want to go back and refight out the remedy of $5,000, because in many ways he's achieved so much by getting where we are, and the litigation coming up behind us is going to do a lot of this. But I don't know. Please don't take that to mean that we won't.
Right.
I'm not in charge. Mike Hausfeld is in charge. I just do what I'm asked.
Certainly makes sense. Well, I imagine we'll be back here on the stage next year discussing this very same issue.
Discussing our big win, discussing my retirement.
We will look forward to both of those things. Anyway, Melissa, thank you so much for being here. Very much appreciate it.
Thank you.